Welcome back to the channel, folks. Today's courtroom session is packed with drama, high-stakes negotiations, and some jaw-dropping financial breakdowns. We're starting with a no-show defendant, always a risky move in housing court, before moving into cases where the judge lays out strict payment schedules that could make or break these tenants' futures. Stick around because we're going to see deals made, deadlines imposed, and some surprising moments of compromise from the bench. My question to you right out of the gate: if you were facing eviction, would you rather fight it out in court or negotiate a payment plan with your landlord? Let me know in the comments, because what you're about to see highlights both the risks and the rewards of each choice.
Sherelle Barksdale versus Leo Stringa. Your name?
Sherelle Barksdale.
And Leo Stringa, not here. This is a termination of tenancy action. He also did not file a written answer. The defendant, having failed to appear and comply with the court's orders, judgment for possession will enter. There is no redemption amount. Writ will issue in 10 days. For my signing. So you'll need to fill out a judgment for my signature. Get a copy at the front counter.
Okay, thank you.
All right, thank you. Take care, Miss Andula. Court calls the case of Steven Weaver versus Eric Buckner. Is this one of Miss Lee's cases? Oh, and Nicole Winnable.
Good morning, sir.
Good morning, sir. Your name?
Eric Buckner.
All right. Where are we on this case?
Mr. Buckner and I have agreed to a COD, which I will submit on the 7-day rule. Should we include the terms as to his wife, who is Ms. Winnable, as a default?
Yes.
And then she's in default, and if we have to come back. So, Your Honor, we agree that today's balance is $5,100.
Okay.
We agree that monthly rent is $2,300. They are going to pay $1,000 today, $700 next Tuesday, and $700 every Tuesday until their balance is zero, but no later than October 31st.
Got it.
So it'll be a total of 51 plus 2,300, which is $7,400 that they'll pay. 1,000 today and then 700 a week until it's paid. They'll pay their monthly rent on time through the end of their lease, which is March, right?
March. Yeah.
Which is in March.
Right here we see the judge break down a very specific payment plan: $1,000 upfront, then $700 every Tuesday until the balance is cleared. Notice how structured this agreement is. It's almost like a layaway plan for housing. What's fascinating is that the judge makes it clear: if even one payment is missed, the landlord can file for eviction immediately. This shows how strict conditional dismissals are. The tenant gets breathing room, but the landlord keeps power in their back pocket. Viewers, do you think this kind of deal is fair? Or is it just setting tenants up to fail under impossible deadlines?
We'll do this as a conditional dismissal. If they comply with those terms, then matter will remain dismissed. If they don't, the landlord is entitled to submit an affidavit of non-compliance, a judgment, and an order of eviction.
Sir?
Yes, sir.
Is that correct?
Yes, sir.
All right. Do you have any questions regarding those terms?
Nope, I'm good.
Okay. When I do sign it, and I just will advise you, since your portion is really a consent, that you would have 3 business days in which to think about it for the date of my signing. If you believe that there's some legal reason, some right you didn't assert, some misunderstanding or confusion, you'd have to file a motion with the court within those 3 business days. You understand that, sir?
I'm good.
All right.
Thank you, sir.
Thank you for working it out.
I will.
Thank you, Your Honor.
Yeah, thank you.
Karen Steele versus Robin Yash.
Maybe approach. Can we approach, Your Honor?
Oh, boy. Yeah, come on.
Thank you.
In this matter, record should reflect the bench conference with counsel slowly but surely things are kind of coming through, and I don't mind giving the parties an opportunity to try to get themselves closer. October final settlement conference date,
October 14th.
14th. Will October 14th work for council?
Yes, Judge.
Works for me as well, Judge.
Okay. So final settlement conference will be adjourned in this matter, October 14th, 2025, 9 a.m.
Thank you, Judge.
Thank
you, Your Honor. Thank you, folks. Thank you. Lori Anderson versus our money line.
Your Honor, for the record, Tish Lee for the defendant, Precious Terman.
This is okay as long as he orders it. Your Honor, I think we have a conditional order of dismissal. I thought I did that when you first called it James Hank for the plaintiff.
All right.
Do we want to approach the bench?
Sure,
Okay.
maybe.
Yes.
Just take a minute. Your Honor, we will submit a conditional order of dismissal that dismisses this case subject to the terms of the order, allows Ms. Terman to retain possession of 833 Armstrong pursuant to the terms of the lease agreement, provided she complies with the order. Her rent due as of today is $2,969. That's rent, costs, and fees. That's her ledger balance. She will pay $98, which is her September rent, on or before September 30th. She will pay the remaining balance after paying that 98 in 6 equal payments commencing October 1st, 2025. If it's the entire balance, it will be $478.50 a month, 6 equal payments for the arrearage, but we expect that she's going to get assistance. And so whatever the balance is going to be divided by 6. That's what she'll pay for those 6 months. It could be as low as $50. She'll pay her monthly rent on time and not later than the 5th of each month. She will timely complete all recertifications, both annual and interim.
Now pay attention to this case. It's a perfect example of the court balancing landlord protections with tenant survival. The tenant here owes nearly $3,000 but gets a deal to break it into 6 monthly payments, all while still paying regular rent. What's interesting is that the judge steps in and adjusts the schedule, pushing payments to the 15th of each month instead of the 1st. Because many tenants are strapped for cash at the start of the month. This small change shows real awareness of financial realities. Do you think the judge was being compassionate here, or just making sure compliance was more realistic?
While this order is in effect, she'll comply with the terms of her lease. If she makes all payments as agreed, no additional late fees shall be added to her ledger. My client can only do that if you order it, and I know from our previous discussions that you order it. So we added it. If she's delinquent, late fees will accrue. If she fails to comply with any terms of the order, we can file an affidavit of non-compliance with a copy to defense counsel. They have 5 business days to file objections. If they object, you'll have a hearing, and it will be based on a preponderance of the evidence, except as set forth in this. The terms of the lease continue. The 14-day objection period of MCR 2.602C2D is waived. The 56-day rule is waived. This order is good for 365 days for enforcement. There's no admission of or a finding of fault or wrongdoing. Court retains jurisdiction, and this is a final order resolving the last pending claim.
All right. Is that a correct statement? Here's the only issue that I have. The additional payment is due at the same time as rent. I have a problem with that. I would rather that the additional payment be due the 15th of the month. And my only reason for saying that is because I just ran into this. I thought about it before, but it just ran into it where they do a recert, the rent goes up, and then there's this huge amount at the beginning. It can be paid if there's like another paycheck.
I'm sorry, Your Honor, they do a research when?
The person did a recert. There was a recert done. Their rent goes up. They had this lump sum payment due all of it's due at the first. And so their rent went up, and then all of a sudden they had this large payment, this payment due.
The rearage payment.
Right.
Made that change, Your Honor.
Okay.
It's the
It
15th now,
just,
so commencing October 15th and then the 15th of each month for those 6 monthly payments on the arrearage.
I just think it's easier for tenants to,
Got it. Got
to
it.
do.
So instead of starting on October 1st, it would start on October 15th.
Okay. I mean, if she wants to pay it early, she can. I just don't want them pinched into a box. Are all those other terms correct, Ms. Lee?
Yes, Your Honor.
All right, very good. Thank you, folks, for working it out.
I just sent it to Ms. Wyling and we will sign it and submit it today.
All right, fantastic. I will
Thank
mark
you.
this file conditionally dismissed. Thank you.
And that wraps up today's courtroom drama. We saw one tenant lose outright by failing to appear, another negotiate a strict weekly repayment plan, and finally, a judge tweaking payment deadlines to give a struggling tenant a fair shot at keeping her home. These cases highlight the razor-thin line between stability and eviction, and how even a single missed payment can turn a deal into a disaster. If you found these rulings as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what's coming next.